Welcome to the deep dive. Today, we're getting into something really technical, but also fundamental to how justice works,
Mhm.
or how it's supposed to work.
Right.
We've been looking at a detailed legal analysis of a tribunal's written decision in a pretty complex employment and disability discrimination case.
And our mission here, for you listening, isn't to retry the case itself. The goal is to see what we can learn about procedural fairness, about this legal idea of apparent bias, and maybe most importantly, the duties owed to a disabled person representing themselves, a litigant in person.
Or LUP, as we'll probably call it.
Yeah, an LUP. We're digging into the arguments the claimant made about, well, about 13 specific patterns of error, things like misstating facts and leaving key evidence out of the official record.
And that's the real tension here, isn't it? It's this clash between the official judicial record and what the claimant says actually happened.
Hmm.
The core of it seems to be whether their rights, under the Equality Act and their right to a fair trial were sort of undermined by the tribunal itself.
It's a huge question. We're basically comparing two versions of history, the official one written by the court and the one you can piece together from emails and transcripts. And, well, they don't always line up.
Let's jump straight into that. Section 1, which the sources call the manufactured narrative of agreement. It starts with the tribunal writing in its judgment that, quote, it was agreed the hearing would go ahead.
And that one phrase, "it was agreed," is doing a lot of work. The claimant's response is pretty blunt. There was no genuine agreement.
So a direct contradiction.
A direct contradiction. The claimant had said on the record multiple times that they were only there under protest and duress, and they gave reasons. Big ones.
Okay, like what?
Well, first, there was a live appeal happening at the Employment Appeal Tribunal, the ET. Second, they were medically unfit to participate because of complex PTSD. And third, they'd asked for reasonable adjustments for their disability, or RAs, and those requests were just ignored.
So if the tribunal knew all that, why write it was agreed? What's the point of putting that in the final judgment?
It's about creating a veneer of propriety, a clean record. If you can say everyone agreed, it protects you from a later challenge, that the process was forced or unfair. It's cosmetic language to make a one-sided decision look like a group decision.
And it seems this also connects to the safety of the whole thing. The tribunal just went ahead and listed these complex remedy issues. Financial loss, injury to feelings, like it was just the next logical step.
Exactly. They treated it like an ordinary post-liability remedy phase. But the claimant argues that was just legally wrong. It's premature and unsafe to decide on a remedy when the basic decision on liability, whether the discrimination happened at all, is being appealed.
Because if the EE overturns the first decision,
The whole remedy hearing becomes meaningless, a total waste of time, and, more importantly, a source of immense stress for a disabled litigant who never should have been put through it in the first place.
so it's not just a procedural hiccup. It's forcing someone to prepare for a hugely stressful event that might just disappear.
Precisely. It gives this false veneer of normal case progression while ignoring the legal reality and the duty to make adjustments.
Okay, let's follow that paper trail. Section 2 gets into the administrative side of things, where a lot of this imbalance seems to come from, starting with the basic framework.
Yeah, and what's so striking here is the lack of a framework. The sources show that for nearly a whole year, there was no valid case management order, a CMO.
And a CMO is basically the judge's roadmap for the case, right?
Mm.
Deadlines, what evidence to share, that sort of thing.
It's the judicial steering wheel, and without it, you get this procedural vacuum. The disabled people is just left guessing while the other side, the respondent, starts to fill that void.
How do they do that?
They start trying to impose their own proposals, setting their own deadlines, making their own rules. They're essentially acting like the case manager because the real one is, well, absent.
And you can see this imbalance in what actually gets written down in the final judgment. The sources point out that the judge meticulously recorded the respondent's 11-page costs application.
Yes, notes its length and detail. But what's missing?
The claimant's situation.
Completely omitted. The judgment doesn't mention that the claimant is a disabled lip dealing with diagnosed PTSD, anxiety, physical problems, and that they had repeatedly asked for help, for RAs. By leaving that out, you erase their vulnerability from the official story.
which makes the tribunal's later decisions seem much more reasonable than they actually were.
Exactly. And that leads to this huge factual error about costs. The tribunal wrote that costs were set to be heard in the absence of any comments from the claimant.
But that wasn't true.
No, the sources say it was factually untrue. The claimant did comment. They objected. They applied for a stay. They told the tribunal about the UPAT appeal. They explained their disability made it impossible to prepare. That's a substantive objection.
So they basically redefined a major objection as silence.
Right. They misrepresented a detailed protest as no comments to justify their own decision to just push ahead.
And this all seems to come to a head with the tribunal's own admission. They admit they responded promptly to the respondent's request to fix some typos in the judgment.
A minor administrative thing.
But then in the very next breath, they admit the claimant's really important disability and stay application was not referred to the judge at that time.
And they call this unfortunate, but it's so much more than that. It's the whole system in microcosm. The respondent's minor convenience is prioritized over the claimant's fundamental legal rights. That isn't just bad admin, it's the very definition of procedural imbalance.
Let's shift a bit to the human element here, because the way the claimant's disability was handled is, well, it's pretty shocking. How did the tribunal frame it?
They minimized it. Deliberately, it seems. The claimant has this complex profile, PTSD, cognitive issues, anxiety, and the tribunal just kept reducing it to something physical and simple.
Like what?
The sources say it was narrowed down to a plug-related foot injury, or just that the claimant was groggy or had difficulty standing.
Groggy. That sounds incredibly dismissive for something like PTSD. What's the legal effect of minimizing it like that?
The effect is devastating. Because if you can frame the disability as something minor, you can ignore the need for major adjustments. The claimant needed procedural help like more time to read a huge bundle of documents because of their cognitive issues. But if you pretend the only problem is a sore foot,
then you can say those adjustments aren't necessary.
Exactly. You sidestep your legal duty under the Equality Act.
Which brings us to the deadlines. The respondent just made them up. They sent a 460-page bundle and gave the claimant, 16 hours to review it?
Yes, acting as if their own proposals carried judicial authority, which of course they didn't. Only a judge can set binding deadlines.
But the tribunal backed them up.
That's the key. The tribunal later called these unilateral, unlawful directions sensible. And for the claimant, that was a huge red flag for an appearance of bias. The court was essentially rewarding the other side for taking over the process.
But the most incredible point, I think, is the ex parte communication, the private chat.
Oh, absolutely. This is a major procedural sin. The tribunal actually admitted in writing that the judge and the panel spoke briefly to Mrs. Hodgetts, the respondent's lawyer, without the claimant there.
And they talked about timings and proposed orders.
Yeah.
How long was this brief chat?
48 minutes.
48. Okay, that is not a quick hello. That is a strategy session. What does the law say about something like that?
The law is incredibly strict. You have cases like Porter v. McGill that say justice must not only be done, it must be seen to be done. A 48-minute private meeting between the judge and one party's lawyer completely destroys that appearance of impartiality. Any fair-minded observer would see a real possibility of bias there.
It just taints everything that comes after.
It does. It fundamentally undermines the integrity of the whole proceeding.
Okay, so let's look at how the hearing was allowed to go forward with all these problems bubbling under the surface. It all starts with the refusal to grant a stay.
Right, which was the most logical thing to do. The ETT appeal was active, but the tribunal refused, saying there was no reason to anticipate that happening in the near future.
Which is just a guess, isn't it?
It's worse than a guess. The sources call it irrational and legally unsound. The claimant had given them formal notice months earlier. An appeal makes the remedy unsafe, period. The tribunal just fell back on this idea of finality, administrative convenience, basically. And they let that override the claimant's right to a fair hearing.
And then we get this truly amazing excuse for their own failures. The tribunal actually admits it failed to issue the CMOs, the roadmaps, because, quote, not all correspondence was referred to the judge.
I mean, it's an astonishingly improper excuse. The tribunal is essentially blaming its own administrative chaos losing letters, not updating the file, to then penalize the claimant for not following rules that were never set.
You can't blame the litigant because your own filing system is broken.
You absolutely cannot. It's a complete abdication of judicial responsibility.
And that leads us to the final, and maybe the most glaring irregularity of all. the retrospective CMO.
Yes. So the tribunal adjourns the main remedy part of the hearing, but decides to press on with costs. And then it says the case management orders for that hearing were made and sent immediately after the hearing.
After. So they're issuing the rules for the hearing once it's already over.
It's procedurally impossible. Think about it. A CMO tells the parties what they need to do for the hearing. You can't get it afterwards. It's a blatant attempt to rewrite history.
To make it look like there was a proper process when there wasn't.
Exactly. It's trying to retroactively legitimize a process that was, from the start, procedurally flawed, discriminatory, and completely non-compliant. It's the smoking gun.
This deep dive has really shown that, well, that the fight for justice isn't just about the big arguments. It's about the paperwork, the deadlines, the integrity of the record.
It is. The cumulative effect of all these small and large failures, erasing the disability, the one-sided communication, the after-the-fact orders, it all compounded the disadvantage of a disabled person trying to navigate the system alone. It makes the final judgment fundamentally unsafe.
So for you, listening to this and trying to make sense of complex sources, this is a masterclass in why procedure matters just as much as substance. Always look for that gap between the official language words like agreed or sensible and the facts you can find in the actual case file.
That gap is where the truth usually lies. And this all shows how easily that procedural language, in the interests of justice, minor administrative error, can be used to cover up massive systemic failures. Which leaves a final question for you to think about.
Go on.
How much of the official history in any complicated, contested process is really just designed to retroactively justify the outcome? And how can you hold a system accountable when it uses its own rules to hide its own mistakes?